What were you thinking while you were doing it? That's what I'm trying to figure out.
I am asking that you put him on deferred adjudication. Notwithstanding the horrible mistake that he made, he has no criminal history. Whether or not the court believes that my client is worthy of redemption, and I would say that he is.
Welcome to the Court of Justice.
Court is calling 2019 CR 6589, State of Texas versus Jonathan Rodriguez. Can I have parties announced for the record for the state? For the defense? All right, are you Mr. Rodriguez?
No.
All right, have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Are there going to be any witnesses or just argument?
This argument.
All right, Mr. Rodriguez, you entered a plea to indecency according to the plea bargaining agreement. Punishment is to be assessed at a cap of 15, and there's to be no contact with the complainant and Chapter 62 registration. The state is opposed to your application, state?
Yes, Your Honor. And I'm to proceed with argument, correct?
Yes.
I didn't want to assume anything. Sorry. So based on the offense date, if you look at the date of birth compared to the defendant's date of birth times the offense, and the defendant was 28 years old at the time of the offense. This case is even more aggravated in the fact that when she went and had her SANE exam, the fact that she had a SANE exam is terrible in itself. But as a result of that, she tested positive for chlamydia in both her anus and in her vagina. What's contained in the STIPs, and I believe the court can consider, is that this penis and her vagina. And so it's clear what other way other than some sex by somebody does it get this. And so these cases are already egregious in the nature that we have a victim whose innocence has been stolen from them. But what's even more aggravating is the age difference of having the offense. And what's even more aggravating is the fact that this defendant, presumably, all the evidence suggests that he is the one who caused her to have an STI at the age of 67 at the time of her outcry. And so we are asking, and I believe justice demands that you deny his application for deferred adjudication, and that we ask.
At this stage, the courtroom faces a difficult question that goes beyond the crime itself. The prosecution has focused on the seriousness of the offense, while the defense is about to argue that the defendant deserves a chance at rehabilitation. From this point forward, every statement will influence whether the judge sees the possibility of redemption or concludes that accountability must come first.
That you sentence him to the full 15 years because of the aggravating nature of this offense.
All right, defense?
Your Honor, obviously these are aggravated facts, but these cases almost always involve aggravated facts. And I think, Judge, what is going to determine how this case goes is whether or not the court believes that my client is worthy of redemption, and I would say that he is. I am asking that you put him on deferred adjudication. Notwithstanding the horrible mistake that he made, he has no criminal history. He's never been convicted of a felony. He's never done time in prison. He's never done time in county jail. This is his first offense, and it is a horrendous offense. But the fact remains, he has no criminal history whatsoever. Further, Your Honor, if there is deferred adjudication, as the court knows, the court would not be limited to the sentencing range that it's limited today in the event that Mr. Rodriguez were to violate his deferred adjudication. Mr. Rodriguez at that point would be facing the maximum, which I think gives him incentive to behave himself while on deferred adjudication. Also on deferred adjudication, the court can order the treatment that he needs in order to rehabilitate himself. And the court could also order conditions to protect the complainant from the defendant. I'm asking, Your Honor, that you put him on deferred adjudication. This is a horrendous thing. There's not really anything I can say about that. But the fact is, I think he's worthy of saving. He has no criminal history. And I do think that I do think that he could right the ship, so to speak, Your Honor.
All right, anything you wish to say?
Um,
Can you raise your right hand for me?
yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. So before you decide to testify, if you decide to testify, the state, of course, is allowed to cross-examine you. Do you still wish to testify?
If I ask you questions, you can ask me questions too. You have to answer. Okay.
All right, what would you like to say?
No, about the probation, if you do give it to me, you know what I mean?
All right, I thought you wanted to say something about the actual
Oh,
allegations.
no, I was gonna say about the probation. Now, if you do give it to me, I promise, Your Honor, that I'll prove to you, and also I'll prove to my brother that's back there and my mom also. And
Why are you kissing his tongue? That's what
Why?
I'd like to know.
Why am I kissing her?
I read all of the PSI reports.
I don't remember doing that, Your Honor.
Why are you penetrating it? I mean, you pled guilty to it.
Yes, ma'am.
So I'm trying to figure out what were your thoughts.
This is often one of the most revealing moments in a sentencing hearing. Rather than asking about legal details, the judge is trying to understand the defendant's own explanation for what happened. The answers given here can shape how the court evaluates remorse, personal responsibility, and whether any request for leniency is genuinely supported.
Process when you were penetrating.
It was, I know I messed up, and you know.
Well, no, my question is why? What were you thinking while you were doing it? That's what I'm trying to figure out.
I can't remember.
Okay.
Sorry.
I mean, I'm just asking questions.
All right.
All right, defense? Any questions?
No, Your Honor. As the court sees, there's what can he say for this? It's horrendous. I just asked the court to show mercy.
All right, any questions?
I think you said enough, Judge.
All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 15 years in the prison, give you credit for any time served. There's Chapter 62 registration and no contact with the complainant. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
That's fine.
Because it's the plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I understand that sometimes people regret what they've done, but we can't turn back the hands of time. So you need to internalize what you've done, and hopefully this won't happen again with you. You understand? All right, is there any impact or no?
No, Judge.
All right, thank you. Is calling 2024 CR 2912, State of Texas versus Refugio Rodriguez. Can I have parties announced for the record for the state?
Second for the state.
Defense?
Monica Guerrero for Mr. Rodriguez, Your Honor.
And this is an application probation.
It is, Your Honor.
Counsel, have you received all of the discovery?
I have, Judge.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state is proceeding on the lesser included offense, assault causing bodily injury, a Class A misdemeanor.
No objection.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family violence as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both questions.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
What's that, ma'am?
The plea bargain page, what your agreement is with the state, did you
Yes.
review that with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor, family violence. Punishments be assessed at 1 year in the Bear County Jail. The state recommends community supervision. There's an affirmative finding of family violence in parenting classes. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes, ma'am.
Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no harmful or injurious contact with the complaining witness. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers states 1 and attachments.
No objection, Your Honor.
All right, did you review the document waiving consent to stipulation of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
As the hearing approaches its conclusion, the focus shifts from the original allegation to the practical consequences of the court's decision. The judge is now weighing supervision, public safety, and the defendant's future obligations. These final exchanges often determine not just the sentence, but the conditions that will shape life after the courtroom.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So,
Judge, it was a plea bargain for 1/2.
oh, 1/2, because I have the document he signed was for deferred or
Thanks for watching and subscribe my channel